Financial crimes are like a virus, silently infecting the global economy. They involve illegal acts committed for financial gain. These crimes are often driven by greed and a disregard for the law, leaving victims with devastating consequences. Fraud, a common financial crime, involves deception for personal gain. Bribery corrupts individuals in positions of power through illicit payments. Money laundering disguises illegal funds, making them appear legitimate. Embezzlement occurs when someone misappropriates funds entrusted to them. Tax evasion is the illegal avoidance of tax obligations. Insider trading, on the other hand, gives an unfair advantage to individuals using non-public information for trading. These crimes, while diverse in nature, share a common thread. They undermine financial systems and erode public trust. Understanding their complexities is crucial in combating this growing threat. Investigating financial crimes is like solving a complex puzzle. It requires meticulous attention to detail, a deep understanding of financial systems, and the ability to follow the money trail. The first step often involves receiving a tip or complaint. This could come from whistleblowers, financial institutions, or even victims themselves. Once a potential crime is identified, investigators gather information from various sources, including bank records, financial statements, and tax returns. Interviews are conducted with witnesses, suspects, and experts. These interviews aim to gather first-hand accounts, establish timelines, and uncover any inconsistencies in the narratives provided. Finally, investigators analyze the collected evidence, often using sophisticated software to detect patterns, anomalies, and connections that might otherwise go unnoticed. The goal is to build a strong case that can be presented in court. The evidence used in financial crime cases is often complex and multifaceted. It can range from tangible documents to digital footprints left behind in the virtual world. One crucial type of evidence is financial records. This includes bank statements, credit card records, loan application, and investment accounts. These records can reveal suspicious transactions, hidden assets, and patterns of financial misconduct. Digital evidence is increasingly important in today's digital age. Emails, text messages, internet browsing history, and social media activity can provide valuable insights into the intent, communication, and actions of those involved in financial crimes. Witness testimonies also play a vital role. Whistleblowers, informants, and expert witnesses can provide first-hand accounts, corroborate evidence, and offer specialized knowledge that helps the jury understand the complexities of the case. Section 4, the uphill battle, challenges in proving financial crimes. Proving financial crimes can be an uphill battle for prosecutors. These cases often involve intricate transactions, complex financial instruments, and sophisticated schemes designed to conceal the truth. One major challenge is the issue of intent. Prosecutors must prove beyond a reasonable doubt that the defendant knowingly and intentionally engaged in illegal activity. This can be difficult, especially when dealing with complex financial transactions, where intent might be obscured by layers of paperwork and legal jargon. Another challenge is the global nature of financial crime. Money can easily move across borders, making it challenging for investigators to track funds and gather evidence from different jurisdictions. International cooperation is often required, which can be time-consuming and politically sensitive. Furthermore, the use of shell companies, offshore accounts, and other sophisticated techniques to hide assets and obscure ownership can make it extremely difficult to follow the money trail and hold individuals accountable for their crimes. Section 5. Defense strategies. Challenging the prosecution's case. Defense attorneys play a crucial role in protecting the rights of those accused of financial crimes. They carefully scrutinize the prosecution's case, looking for weaknesses, inconsistencies, and procedural errors that can be used to challenge the evidence presented against their clients. One common defense strategy is to attack the prosecution's narrative. Defense attorneys might argue that the alleged crime was not a crime at all, but rather a series of legitimate business transactions. They might present alternative explanations for suspicious financial activity or attempt to discredit the prosecution's witnesses. Another approach is to challenge the admissibility of evidence. Defense attorneys might argue that evidence was obtained illegally, that chain of custody was broken, or that the evidence is irrelevant or prejudicial. They might also file motions to suppress evidence or dismiss charges if they believe the prosecution's case is weak or flawed. Defense attorneys also focus on protecting their clients' rights throughout the legal process. This includes ensuring their clients understand their rights, are treated fairly by law enforcement, and have access to legal counsel at every stage of the investigation and trial. Section 6. The stakes are high importance of thorough investigations and defenses. Financial crimes pose a serious threat to our economic stability and erode public trust in financial institutions. Thorough investigations are crucial to uncovering these crimes, bringing perpetrators to justice, and recovering stolen funds. Law enforcement agencies need the resources and expertise to investigate these complex cases effectively. This includes access to sophisticated technology, specialized training, and the ability to cooperate with international partners. At the same time, it is equally important to ensure that those accused of financial crimes receive a fair trial. Defense attorneys play a vital role in upholding due process, challenging the prosecution's case, and protecting the rights of the accused. The pursuit of justice in financial crime cases requires a delicate balance between thorough investigations and robust defenses. By strengthening both sides of the equation, we can create a system that effectively combats financial crime while upholding the principles of fairness and due process.